Johnny for legal aspects in the tourism and hospitality industry. No? But before we start my lecture, which will be a new topic by the way, let's just have a recap of what we have taken yesterday. Of course, the most important thing that I could advise you when it comes to obligations and contracts, because that was our topic yesterday and last Monday. Now, what I can advise you is that in obligations and contracts, of course, everything that will be agreed upon by the parties. Who are the parties again? In the case of a contract, it will be the offeror and the offeree. Now, before there will be a what we call the perfection of a contract, of course, my advice to you is you should read all the stipulations. We call it the stipulations. You should read all the contents of the contract before you affix your signature into it. Because once you affix your signature to a contract, you have signed the contract already, then you will be bound. No, you will be bound by all the provisions stated therein. Why is that? Well, one of the characteristics of a contract is it has an obligatory force. You know that, no? That means that you will be bound, no? Because there is an obligatory force that we call. Also, there is another characteristics where we said that there is mutuality, no? Mutuality of the parties, no? Mutuality meaning those parties who enter into such contract will be bound, no? Both parties will be bound. So the most important advice for you is someday, somehow, when you sign a contract or an agreement, you have to read first all the provisions that have been written down therein. Okay, now that you know about obligations and contracts, we have to leave that. We go to another topic which we call labor law, no? Labor law, or otherwise known as employment law, no? Employment law. Of course, labor law could be found in this law, no? The Labor Code of the Philippines. This is the governing law when it comes to employment. And this labor code, our labor code, applies only to those people or workers who are employed in the private sector. No, because the government, those who are employed in the government, they are governed by another law, which we call the Civil Service Law. I repeat, as a tourism professional, someday you will be hiring workers. No, someday when you are managing already a tourism establishment or a business establishment, of course there is a need for you to hire people. And being employed in the private sector will require certain issues, no? Certain issues may be about employment issues, no? Or labor issues. And of course, those who are in the private sector, they are governed by the provisions of the labor code. Now, okay, I will write it down so that you will easily remember. Now, for lack of material time, of course, labor code, no? Labor code of the Philippines, no? LCP of the Philippines. Now, this is the law that pertains to what we call employment, relating to employment matters, no? Employment matters in the, remember this, the labor code applies only for people or personnel in the private sector. Those who are employed in the government, they are governed by another law which we call the Civil Service Law, no? So remember that the labor code applies only to those employed in the private sector. But before we start discussing about employment law, or labor laws, there is a need for you to know the provisions in the Constitution or constitutional provisions, no? For lack of material time, no, which will be the basis, no, of this labor code of the Philippines. So for lack of material time, we could not discuss all the constitutional guarantees affecting labor. So what I would do now is just to mention to you the specific provisions in the Constitution that affect the labor sector. Okay, remember. So do you have a pen already? If you have a pen where you could write down the specific provisions that affect the labor sector, please read all these provisions. I understand that you have the Constitution with you. You bought this when you were in first year, so there is no problem referring to the constitutional provisions. I will mention them one by one, then you read and understand, of course, no? So under Article 2, you read Section 9 on state policies, Section 9 of Article 2, then Section 10. Okay, are you writing it down? Section 9 of Article 2, Section 10 of Article 2, Section 18 of Article 2, Section 19 of Article 2, okay, Section 20 of Article 2, Section 23 of Article 2. Of course, when you read Section 20 of Article 2, you have to relate this to Section 8 of Article 3. Okay, clear? When you read Section 20 of Article 2, you have to read also Section 3, or Section 8 rather, Section 8 of Article 3. Okay, and then when you read Section 23, you also have to read Section 8 of Article 3 and also Section 15 of Article Section 15 of Article what's this? Article 12, no? Okay? So those are the specific provisions in Article 2. Now we move on to Article 12. You have the Constitution with you. We move on to Article 12. No, you read and understand these constitutional provisions that relate to the labor sector. No? You read Section 1. Article 12 will be the national economy and patrimony. No? You read Article 12, Section 1. Okay? Read Article 12, Section 1. You read Section 10 of Article 12 also, no? Section 10 of Article 12. Then you also read Section 12 of Article 12, no? Also Section 14 of Article 12. Then last will be Section 15 of Article 12. Get that? So those are the provisions that apply to the labor sector under Article 12. Now we move on to Article 13, 1.3. Article 13 talks about social justice and human rights, no? So under Article 13, you read Section 1, Section 2, Section 3, Section 14, no? Section 1, Section 2, Section 3, then Section 14 of Article 13. Okay, so then last will be Article 14. Is this the last, or there's Article 15? Okay, the last would be Article 14. You read Section 2 of Article 14. Article 14 talks about education, science and technology, arts, culture, and sports. So you read section 2. You read also, particularly in section 2, number 5. No? Number 5 of section 2, article 14. Also read section 4 of article 14. No? Section 4 of article 14. Then, of course, section 5, number 2. No? Section 5, number 2, and number 5. No? I repeat, section 5, numbers 2 and 5. Okay? And then, of course, you have to read also section 11. Okay? Section 11 and then section 12 of that article, article 14. Okay? So those are the specific provisions that relate to the labor sector. But of course, the primary law that will contain all the provisions that affect the labor will be the Labor Code of the Philippines. This one is, of course, a very old law. It's Presidential Decree number 442. No? So the number of this law, if you want to read some more, will be Presidential Decree 442. No? And PD 442, of course, took effect when? When did it take effect? It took effect on May 1, 1974. So it's a, it was first promulgated on May 1, 1974, but it took effect 6 months after, on November 1, 1974. Okay? By virtue of a specific provision therein. Okay? So I repeat, this one is the governing law when it comes to employment matters. No? This is the governing law on employment. Governing law on employment matters. No? Employment matters. Now, the number of this law is, I mentioned it earlier, it's PD number 442. Of course, it's a PD, it's a presidential decree, because before President Ferdinand Marcos was authorized to issue presidential decrees on certain matters, no? PD 442. And this was promulgated by President Marcos on, I told you, May 1, 1974. But by virtue of the specific provision in the Labor Code, it will take effect 6 months after its promulgation. So it became effective on November 1, 1974. That's 6 months after May 1, 1974. Clear so far? So I mentioned to you already the specific constitutional provisions that affect labor. Now we proceed with the more important provisions. By the way, we could not discuss all the provisions in the Labor Code because this one is a course in HRDM that will take you 2 semesters, no? 2 semesters, 2 semesters to take up, no? To take up. In law school, we have Labor 1 and Labor 2, no? So it takes 2 semesters for us to study the Labor Code of the Philippines. So I do not intend to delve deeper. But what I want is, of course, just to remember the important principles in Labor Code. Okay, so today I will be discussing to you what are labor standards. So these are classifications of laws or legislation. Then we have labor relations, no? And then of course we have the social legislation, social or welfare. We call that the welfare legislation, no? social legislation or welfare legislation. Of course, we have to take this one by one so that you could easily understand what are labor standards. Of course, when we talk of labor standards, we are talking about specific provisions in the labor code that pertain to what? Well, the term alone, standards, but we have to know what these standards are. We are talking about the terms and conditions of employment. The terms and conditions of employment. No, you know that when you are hired, when you get a job, there is an employment contract, and that employment contract will specify the terms and conditions therein. What are these terms and conditions that are today? Well, it has to, with respect to wages, your salary, no? With respect to benefits, like say for instance, wages and the conditions of work. No? Of course, it has something to do also with hours of work. No? These are terms and conditions of employment, hours of work. No? And then what else? Overtime pay, OT, no? Night shift differential, meal periods, no? Meal periods, usually you are given 1 hour as your rest day, rest periods, etc. So these are what we call the terms and conditions of employment, and this one will be covered by what we call one branch, which we call the labor standards, no? Laws, no? Labor standards, laws, no? When we talk of labor standards, we talk about the terms and conditions of employment. We talk about the wages, the salary, conditions of employment or conditions of work, hours of work, overtime pay, night shift differential, rest period, meal periods, etc., etc. No? Okay, clear so far? Now we move on to the other piece of legislation on labor, no? And we call them the labor relations, no? Labor relations. So we have labor standards, we also have labor relations. Well, by the term alone, it pertains to what? Relationship between the employer and the employee. So these are the parties to a contract, employment contract. We call that the employer. The one who hires you is called the employer, and of course the employee. No? Clear so far? And of course, between the employer and the employee, there is a relationship that is established. No? There is a relationship. So employer-employee relationship. Once you are hired, then there is a relationship that is established, and we call that the employer-employee relationship. Clear? Are you still with me, Ms. Joni? Do you still understand? And these ones, when we talk of the relationship between the employer and employee, that pertains to what we call labor relations. There, and there are pieces of legislation that affect the labor relations, no? But it doesn't mean that it does not also include labor standards, because this is more comprehensive, no? The coverage of labor relations is more comprehensive than labor standards. Now, what is being taken in labor relations, of course, as I told you, will be the relationship between the employer and the employee. Now, usually in labor relations, this is where negotiations come in. No? Negotiations about what? Well, negotiations also about terms and conditions of employment. That's why I told you, in labor relations, this is a more comprehensive classification, because even terms and conditions are also being tackled in labor relations legislation. Negotiations with respect to terms and conditions of employment. And this is also where we come in what we call the CBA. No? What is the CBA? Collective Bargaining Agreement. The CBA is the Collective Bargaining agreement. Here so far, collective bargaining agreement. This is when there is when the establishment is unionized. There is a union, no? Unionized, no? There is a union. So the agreement between the employer and the employee would come or will be reduced into what we call a collective bargaining agreement. And this will apply to all union members. Clear so far? And I told you, this one has something to do with labor relations, the employer and employee relationship. So in case they do not agree with the terms and conditions under the CBA, the weapon of the employer will be a lockout, no? And the weapon of the employees will be what we call the strike. Here, so here in negotiations, of course, it also involves unions, no? The forming of unions, because this one will represent the employees. But for now, I'd like to impress upon you that when we talk of labor relations, we are talking about the employer-employee relationship. And that employer and employee relationship would involve, again, negotiations. And how do negotiations will be done? Of course, through the union. This one will represent the employees, represent the interest of the employees. Okay, clear? That's labor relations, no? So those are the classifications of, there is one more, and we call that social or welfare legislation. Social, or what we call welfare legislation. Well, of course, when we talk of welfare, we talk about the well-being of the employee, no? Welfare, no? So here, it has something to do with the benefits that an employee will be entitled to by virtue of, say for instance, you were affected because of the hazards of employment. Hazards of employment. So it might have something to do, these hazards may have decapitated you. There is a loss of earnings. Loss of earnings by virtue of an injury, no? By virtue of death, or etc. You know, these hazards in your employment may result to an injury, may also result to death. So remember that when we talk of social or welfare legislation, we're talking about the benefits that the employee may be entitled to, brought about by certain hazards in his employment, and these hazards may have affected his earnings because of injury or death. Okay, clear? So moving on, by way of a review, so when it comes to labor laws, no? There are three major classifications, no? First would be the labor standards. What are labor standards again? Well, of course, the terms and conditions of employment. Then we have labor relations. What are we talking about here? Well, of course, we are talking about negotiations. We are talking about forming of unions that will represent the interests of the different employees in a unionized establishment. And then third, we have the social or welfare legislations. Okay? Social or welfare legislations. Clear so far? So these are the different classifications of labor laws in our country. But remember that the Labor Code of the Philippines is the governing law, no? When you want to refer anything about employment, you refer to Labor Code. But this applies only to employees in the private sector. Now, the most important question that I'd like you to remember is, how do we know that there is an employee relationship? No? This is the question. How do we know that there is an employer-employee relationship? Because anything, no, the applicability of the labor code will depend on the existence of the employer and employee relationship. You understand, Miss Joni? Am I talking too fast? But because of lack of material time, we have to move on this way, no? So the most important thing for you to consider then, if the labor code applies, will be this: determining whether an employer-employee relationship exists. Why is that so? Well, because you can only file for something like illegal dismissal or pecuniary benefit or interest if there is an employer-employee relationship that will be within the purview of the labor code. Okay? So now, how do we determine if there is an employer-employee relationship, no? So that the labor code of the Philippines will apply to your situation? Now this, it has been settled by jurisprudence that there is a fourfold test, no? There is a fourfold test to determine, so four, no? Meaning apat, to determine that an employer-employee relationship exists. Clear so far, Miss Joni? Why are we so concerned about determining about this employer and employee relationship? Well, of course, for us to know whether that situation or whether that condition will apply the labor code, no? So it's very fundamental and basic that we should determine first the employer-employee relationship, no? So what are the fourfold tests that you know? Well, fourfold test, remember this, Miss Johnny? Fourfold test to determine whether there is an employer-employee relationship. Well, of course, the right to hire, no? The right to hire by whom? Well, by the employer, no? The employer is the one who hired the employee. So here, when we talk about the right to hire, we are talking about the selection and engagement of the employee by the employer. So this is number one under the fourfold test. There is the right to hire, no? The selection and engagement of the employee by the employer. So number two would be, what do you think? If he has the right to hire, he has also the right to fire, no? The right to fire would mean he has the right to dismiss or sever the relationship, no? The dismiss, sever, or terminate the relationship, no? The word there is dismiss or terminate the relationship. You have to memorize this fourfold test, Miss Johnny, because this is very important for you to determine the employer and employee relationship. So he has the right to hire, he also has the right to fire the employer, and of course, yes, you can also determine if it exists because the right to pay the employee's wages or compensation. Wages or compensation. The right to pay the employees wages or compensation. The employer is the one paying the wages or compensation of the employee. Then finally, we have the most important test would be what we call the control test. The control test. Remember this, Miss Johnny, this is the most important of all the four elements of the fourfold test. Most important, the control test. Remember this. And what is this control test? Well, the control test would say that it is the employer who directs, no, the means and the methods to accomplish the work. To accomplish the work. The work of the whom? By the work of the employee. So that is, if the employer is the one directing, no, the means and the methods by which the employee could accomplish his work, then there is the control test, which is the most important of what we call the fourfold test, that determines whether a certain person is an employee of an employer. So to recap, we have the right to hire, no, by the employer. Also the right to fire. The right to fire also, this belongs to the employer. The third will be the right to pay wages or compensation, no, also by the employer. And then finally, the control test. Control test. If all these elements or requisites are present, then you could say that there is an employer-employee relationship. Okay, I will stop from here. No, I will stop there because it might take a long. This is a very long subject, but I will be discussing only for 2 days for lack of material time. Anyhow, at least you know what labor code is, what employment law is. I will continue again by tomorrow. Okay, good afternoon.